Okay, we now move on, and thank you very much. And we have Margherita Colangelo, who is going to talk about intermediation and EU competition rules in digital markets. Please.
Okay, thank you, Mr. Chairman. So I would be the first lawyer speaking today, and I would like to start by saying that the intermediation activity in digital markets and in e-commerce has been object, of course, of a wide literature up to now in the fields of economics, whereas really little work has been done by legal scholarship, in particular with regard to the competition law implications of this phenomenon. And it has been developed only very recently. Now, some of the things I'm going to say have already been anticipated, so I will go very quickly on these points. I intended to start by some very general but necessary considerations that are necessary for competition law assessment and enforcement. So, of course, so leaving aside the delicate issue of the definition of the relevant markets, once it has been assessed that traditional categories of competition law may be applied in digital markets, in the sense that really the anti-competitive conducts and agreements that we can find in e-commerce do not substantially differ from what we can observe in traditional retailing, then only recently scholars in the legal field have started working on the implications of the presence of multi-sided platforms and of the growing role of internet intermediaries. Well, so among the features of the digital markets which are relevant for competition law purposes, as it has already been anticipated, of course we can mention the tendencies towards the winner-takes-all competition for the market. In particular, literature on the topic has affirmed how competition in this kind of market tends to have a cyclical nature, meaning that successful digital platforms tend to acquire a significant but also transient market power. And thus, given the vigorous competition existing between different platforms, it can be really hard to determine the point at which a firm can be considered dominant for competition law enforcement purposes. In addition to this feature, other elements of complexity, of course, derive from the dynamic competition concerns that we have already seen, and also from the existence of forms of coordination and cooperation between firms that are related to the increasing degree of interconnection of the undertakings working in this field of the platforms, and also these forms are also to be considered having pro-competitive effects indeed. Thus, all these elements result in the fact that really the optimal market structure for these kind of markets is really an unsettled issue, and moreover also the timing for the appropriate timing for the intervention of the competition agencies is also a very debated topic. So focusing on the role of the intermediaries, we know that we have several types of intermediaries, and also that this category is very homogeneous, very heterogeneous, and also the differences between them are not always so clear-cut, in the sense that sometimes internet intermediaries may also play several roles simultaneously, competing with one another, such as intermediaries and users, content and service providers. So in these slides I've just listed the main functions of the internet intermediaries as identified by the OECD. So very quickly, of course, providing infrastructure, collecting dispersed information, facilitating information exchange, aggregating supply and demand, and so on. So just to briefly show that really it is evident that there is, of course, room for issues to be relevant under competition law. So now, Having said that, really, traditional competition rules are not markedly different in the online markets than in the offline markets from which they have emerged. And focusing on the e-commerce sector, we know that e-commerce is now at present a central issue at both national and European level. And of course, at the European level, the sector inquiry launched by the Commission testifies this trend. And if we look at the past experiences with the previous sector inquiries, such as, for instance, in the pharmaceutical sectors, the current inquiry is likely to open the door to many investigations against several companies. And really, we already have some first examples on which rely. So, as a matter of fact, as anticipated also by the chairman, recent case law testifies that one of the key concerns of competition authorities in these years is the use by online platforms of a type of agreements which is generally traced to the category of the most favored nation clause, which is a clause originating in international trade agreements and also widespread in the which has developed also in traditional brick-and-mortar retailing. And this clause is typically included in B2B long-term contracts where the supplier undertakes to guarantee the best price conditions to the intermediary concerned compared to any other dealer. And scholars have recently started to study these clauses in the digital environments, and we have different terminologies that have been proposed. The first one is the across platforms parity agreements, which has been proposed by the LEAR, and this is of course the first comprehensive study on the topic. And I think that this terminology has been recently, last month, also adopted by the OECD in the roundtable, which has been held last October in this field. So this is the, let's say, the dominant terminology. But we have also other terms used in the literature, such as retail price MFN, platform for MFN agreement. So I will refer to these terms in the same sense in this presentation. So if we refer to the platforms, in this case, so the upstream seller undertakes to charge on the electronic platform a price that is not higher than the price charged on other platforms, including the new entrants. And let me just point out that a very important point is the business models, which is adopted by the platform at issue, and the currently, one of the most widespread model is the agency model, in the sense that it has been adopted by very large market players such as Amazon, Apple, eBay, Booking. And under this model, the suppliers set final prices so that the intermediary facilitates the transactions between the upstream supplier and the buyer, earning profit from the sale fee. So it is really different from the traditional wholesale model. And we can also distinguish between a wide MFN and a narrow MFN, whereas in the latter, we had the clause links the price and terms quoted on an online platform to those available directly on the upstream supplier website, so ensuring also that the former will be not less attractive than the latter, and a wide MFN where this parity of pricing applies to really to all the channels available, so not only to the intermediary concerned, but also the other platforms and also generally the offline channels. From a competition law point of view, the evaluation of such clauses is very controversial, both in traditional retailing and in digital markets. So in the slides, I've just listed the main arguments supporting the anti and the pro-competitive effects of such clauses. So in a nutshell, we can say that the potential pro-competitive effects of such clauses are essentially identified in terms of price transparency, reduction of transaction costs, mainly in the sense of search and bargaining costs, and trust deriving from brand reputation. However, these kind of clauses also give rise to main competition concerns. Although they are generally traced to the vertical agreements, their main anti-competitive effects take place on an horizontal level and concern the foreclosure for market entry of new resellers, the reduction of competition and facilitation of collusion between resellers, and in the case of the platforms, of course, this collusion is considered to be also favored by the availability of the information and by the price transparency typical of the internet. So, of course, this condition provides a greater incentive for platforms to increase the fees imposed on suppliers and then finally, of course, on final prices. If we look very, very quickly at the relevant case law, we may refer to, of course, to the e-books case, price comparison websites in the field of motor insurance in the United Kingdom, and in the fields of electricity and gas prices in Germany, online travel agencies, and also the Amazon investigation, which is now ongoing at European level, but we had already 2 investigations in Germany and in United Kingdom concerning the parity clauses adopted by Amazon. So, from the competition law point of view, there are really many knots to untie, and there are currently at least 10 different countries in Europe alone whose competition authorities are investigating such clauses now. I will concentrate on the case of the online travel agencies as it is emblematic of the various aspects that result critical in competition law assessment of such clauses, and also reflect the outcomes of the different approaches that may be adopted at EU at national level by the national competition authorities. A common feature of all the investigations that I have mentioned is that they involved these APAs, or retail price MFN clauses, negotiated, of course, by a party, which is the intermediary, who neither sells or buys the goods or service concerned, but also only earns a commission on the sale executed on its platform. So we had a first investigation in the United Kingdom with regard to the online travel agency cases, and here the OFT issued a decision in 2012. This decision was directed against Booking, Expedia, and an hotel chain, so the Intercontinental Hotel Group, on room-only hotel accommodation booking. And this decision has been closed by accepting the commitments offered by the defendants, according to which discounts were allowed to a specific, let's say, a definite category of customer, which has been called as closed group members. These decisions has been quashed by the Competition Appeal Tribunal after the appeal of the MetaSearch website, which is Skyscanner, and now the investigation last September has been definitely closed by the successor of the OFT, which is the Competition Market Authorities, on administrative priority grounds, and I will turn back on this point in a minute. Then we have the investigation in Sweden, Italy, and France. In this case also we have the parity clauses are the object of the investigation between Booking and Expedia and the hotels. And also in this case we have the closing of the investigation under commitments. In this case the 3 national competition authorities have worked in coordination under the supervision of the European Commission, and now the outcome of this commitment proposed by Booking, admitting the narrow MFN. So the MFN clause may still be applied with regard to the platform at issue and the direct online website of the hotels, but it will be not extended to other platforms. And then we have the German case, which regarded parity clauses applied by a large portal, which is the HRS portal. In this case, the decision has been closed through a prohibition decision, and this has been also confirmed in courts by the Düsseldorf Higher Court. And now the German authority has also started investigation against Booking. After the commitments accepted in the Swedish, Italian, and French case, Booking had declared to amend its parity the parity clauses throughout Europe, and so did also Amazon. For this reason, the Competition Market Authority in the United Kingdom decided to not continue the investigation, also declaring that really the effects of the changes of this pricing policy is too soon to evaluate such effects, and that thus has left the floor for more evidences on the potential anti-competitive effects of such commitments. Now, what are the theories of harm that we can find in these investigations? If we look at the investigation by the national competition authorities, the theory of harm is mainly based on the collusion. So, as the chairman anticipated, they are mainly based on Article 101 of the treaty, and so there are some relevant questions that comes from this kind of assessment. And so, first of all, are the intermediaries at issue, so the online travel agencies in these cases, to be considered as genuine agents or as independent resellers? We know that competition rules generally reserve a special treatment for agency agreements, and this applies in the EU but also in the US. If we look at the guidelines on vertical restraints, we know that the determining factor in defining an agency agreements for the purposes of the application of Article 101 is the financial or commercial risk borne by the agent in the activity conducted on the behalf of the principal. And well, there are really opposing views on this point, in the sense that in the case of electronic platforms, according to some authors, really the platforms, and in the online travel agents case, it has been sustained by many works in this field. They do not bear really any risk with regard to the activity of the principal, as they do not buy the rooms, for instance. So the hotel remains the only undertaking carrying the risk for not selling a particular room or a particular service. Differently, others consider the substantial market-specific investments made by the platforms, and moreover the fact that really these kind of clauses are generally requested, let's say, imposed by the resellers, so by the platforms. Well, these features would preclude the finding of a genuine agency agreement. And in fact, the national competition authorities in their investigation have considered, of course, the platforms as resellers, so that traditional competition rules do apply to these actors. And this interpretation has also been upheld by the Commission. Then another controversial issue is concerned the treatment of these clauses, the MFN clauses, under Article 101, due mainly to the fact that, except in the English case, all the investigations conducted are directed against only one party to the agreement, and the decisions taken are addressed to only one of them, the platforms in particular. So if we look at the national investigation, the focus is on the role of the online travel agencies. Their market power is generally strongly stressed, although they are not identified as holding a dominant position, either individual or collective. Only in the French investigation we have a very quick reference to this possibility, but it has not been assessed. So This, of course, would represent a misleading and anomalous application of competition law in the sense that it is true that, of course, the significant market power of the platform may be the only explanation for a supplier to accept these clauses. However, if the theory of harm is based on Article 101 and thus one agreement, hotels should be considered as victims. We should be not considered as victims, but as willing participants, let's say. So at the same level of the online travel agents. Otherwise, it would be more appropriate to consider these conducts as unilateral and then assess them under Article 102, so only when the platforms, the online travel agency, in this case, are found to be dominant. As I said before, the conducts at issue are generally considered within the category of vertical agreements, in particular in the form of the minimum RPM. Really, some scholars have affirmed that retail price MFM represent the worst side of RPM, as they distinguish between the explicit very vertical element, whereby an upstream firm sets final downstream retail prices, and implicit horizontal element whereby the upstream firm sets identical retail prices across all downstream intermediaries, which is of course of major concern. And this implies relevant consequences for competition law enforcement, also considering the divergences between the approaches already adopted in the EU and in the US. In the EU, we know that minimum price fixing is still considered per se illegal, whereas in the US this approach has been superseded by the adoption of the rule of reason after the overruling of the Supreme Court in the Leguin decision. So as a matter of fact, economic theory has also demonstrated the existence of pro-competitive or neutral effects of minimum price fixing, as such an approach has been implemented so in the US, and this may also suggest the need of a rethink of the presumption of illegality still exists in the European Union, and the adoption maybe of a more flexible approach. However, on this point, once again, for a confirmation of the European approach, if we look at the online travel agency case, and we look at the words of the former director Italianer, he has pointed out as two elements really arise from case law in the online booking sector, which are considered of major concern for the European Commission. So firstly, the shifting of the balance of power in favor of the reseller, and secondly, the combination of the RPM with retail price parity clauses, resulting, according to the former director, in a strong potentially anti-competitive effect. Now, in order to conclude, so waiting for the sector inquiry and also for the closing of the investigations concerning Amazon, I would like to make some final consideration with regard to the relevance of a clear competition law approach in this field. So, well, the main problem appears to derive from the lack of an assessment by competition agencies on the clauses at issue. Only in German case we have really a full assessment, as we have mentioned. And the other case law confirms the current tendency at the European level to deal with cases in digital economy by way of commitment decisions, which is, of course, a strategy which leaves many questions untested, including the finding of a dominant position. And as I mentioned, it seems that the treatment of these cases under Article 102 seems to be more appropriate. Then let me recall then, except for the German case, all the other cases have not been challenged in courts. That's in particular with reference to the European level. It remains to be seen whether a European court would upheld such an approach. Also considering the actual trend towards a more restrictive interpretation of the object box after the Groupement des Bancaires case. Moreover, from a strictly legal point of view, the absence of a clear assessment may have also critical consequences on the effectiveness of the commitments and on legal certainty. Once again, the case of the online travel agents is emblematic. In fact, after the commitments by booking were accepted, the French Constitutional Council has adopted specific rules for online platforms, banning all types of parity clauses, including the ones that were allowed under the investigation made by the French authority. This is the Loi Macron. And a similar provision has also been proposed in Italy in the DDL Concorrenza, and it is now subject to the approval of the Parliament. Thus, in conclusion, the current lack of a clear approach has led to the possibility by the national competition authorities to reach different solutions, and also the possibilities of such anomalous and also disputable intervention by the governments through ad hoc legislation in this field. All these elements, of course, result in the risk of an incorrect and unfair outcomes with a sensitive reduction in legal and business certainty. In this sense, it seems that now the burden would be on the European Commission to solve the problem and to provide a definite guidance on this issue. Thank you.
Thank you very much. A few questions, maybe a few minutes. Well, I have a question, and it's related to the UK. I just wondered what happened exactly. I didn't quite understand. Who challenged the decision with the Competition Appeals Tribunal? Also, that one was a commitment decision, and so I wonder who had the stand and why did they challenge?
Yes,
because Arrosa is a little different. We have another case. We have one other case in the European case law, which is Arrosa, where indeed commitment decisions were taken up, and but there it was a different situation, if I understand.
Well, really, in the United Kingdom, we had firstly this investigation by the OFT, and the investigation was directed both against the online travel agents at issue and also to the hotel chain, which is the Intercontinental Group. Yes, and then finally they provide these commitments to the OFT, under which discounts were really allowed to definite categories of people. Let's say these closed group members. Skyscanner, which is a meta-search website, has challenged these commitments in the sense that they have been found as not remove the anti-competitive concerns for the other platforms existing operating in the markets. And the Competition Appeal Tribunal has dwelled on this point and has reminded the case to the competition to the successor of the FT, so the Competition Market Authority. And now the Competition Market Authority decided to not decide on this point. This is the UK case, and it is of course different from the others, as we have the theory of harm of the Article 101, but we have the idea of an agreement. So also the hotels are addressee of the decision.
Thank